Hi, I'm Anthony Diosdi. I'm a tax attorney in San Francisco with over 20 years experience in international and domestic tax planning and tax litigation. You can find me at sftaxcounsel.com. Today we're going to be talking about the Form 5472 and its associated penalties. So, what is a Form 5472? A Form 5472 there's a Form 5472 is a requirement when you have a foreign individual that owns a U.S. LLC or a U.S. corporation, or a foreign corporation that owns a U.S. LLC or a U.S. corporation. And the purpose of a Form 5472 is to tell the IRS if there's any type of reportable transactions that require transfer pricing or is subject to U.S. income tax. So if you, let's just say you are a foreign investor and you want to go ahead and sell on Amazon, this is how I typically see a Form 5472 requirement. So if you're a foreign investor and now you want to go ahead and sell items on Amazon, what typically winds up happening is the foreign investor will go ahead and set up an LLC in a state such as Wyoming or Delaware or Nevada that doesn't have any state taxes on an LLC. What a lot of foreign investors don't think about when they set up their enterprise here in the U.S., or their business here in the U.S., they don't think about the U.S. tax consequences. And one of the most serious tax consequences, or filing consequences, should I say, is this Form 5472. You have to file this whenever there's a reportable transaction. What's a reportable transaction? A reportable transaction is funding your U.S. company. Let's just say you want to go ahead and fund the company for whatever reason. If you go ahead and you fund your U.S. entity, that is a reportable transaction that needs to go on to a Form 472. If you are making money in the U.S. and you are transferring money from your domestic entity, from one entity to another domestic entity, or money's being transferred back to you outside the United States, that also goes on a Form 5472. Along with the Form 5472, there's another form that needs to be filed at the Internal Revenue Service, and that's called an 1120F. But the more serious form is that Form 5472. And why is it serious? Because the IRS can and will assess a penalty of $25,000 for not timely filing that Form 5472. And it's assessed annually. So it's really, really important to understand how important this form is. And if you don't file it timely, how you can be subject to this $25,000 penalty. The other issue with this Form 5472 penalty is that the IRS assesses it automatically. It is an automatic penalty. Let's just say 1 year goes by and you're supposed to file that Form 5472 and you don't, and the following year you file it and you think that you can catch up. When you file that Form 5472 late, the IRS will automatically assess a $25,000 penalty against you. And if they ask you to file it and you do not file it, the IRS will assess another $25,000 penalty for each 90-day increment, and it eventually goes down to a 30-day increment. So they can assess a $25,000 penalty against you in increments as long as they want until you actually file that Form 5472. And this doesn't matter if you made money or you didn't make money on your business. If you have a Form 5472 requirement, you got to file it. Now, what I've noticed in my practice is that a lot of people do the knee-jerk reaction. They think that they have to file the Form 5472 regardless. What I've seen is a lot of clients, they set up their business. They didn't make any money. They didn't fund the U.S. entity in any way. And they go and file the Form 5472 just as a knee-jerk reaction, but they file it late, or they file it for a number of years late because on the advice of some tax preparer who didn't know what they're doing. And the IRS will assess the $25,000 penalties against them, regardless of the fact that the Form 5472 had to be filed or not. All right. So now, since we have a basic understanding of the Form 5472 and a basic understanding of this $25,000 penalty, well, what do you do if you or your company has been assessed this $25,000 penalty? What can you do to try getting that removed? Well, the most common way of trying getting it removed is to go to the IRS and send the IRS a letter. Try to convince the IRS to remove it. Anybody who thinks that they could just simply send a letter to the IRS to have this penalty removed, or hire somebody who doesn't understand the law behind how you remove a Form 5472 penalty is in for a rude awakening. The IRS does not remove these penalties easy. They are very, very strict about assessing them, and about removing them, it is very difficult. And even if you have a really good argument, in my experience, a lot of times you go and you get that really good argument out to the IRS, they'll reject it. And you're going to have to go ahead and actually file an appeal within the IRS to try to get that penalty removed. So now, let's just say you're on that point where you're ready to write that letter to get that penalty abated or removed. What are your arguments? Well, the first argument is reasonable cause. Okay, what is reasonable cause? Reasonable cause is if you became really ill and you're hospitalized, and because of that, you couldn't file that form. Another form of reasonable cause is reliance on a professional. Let's just say you sought out the opinion of a qualified international tax attorney or international tax accountant, and this individual told you that you didn't have to file that form, and you have a letter from them stating it. That's reasonable cause. Anything else? I didn't know the law. Gee, this is the first time. The IRS will not remove that penalty. It's just that that's the way it is. So reasonable cause, here's your exceptions. Illness, reliance. And even with those two compelling arguments, a lot of times IRS still does not remove those penalties easily. You still have to go ahead and put up a very vigorous argument in the form of a very well-drafted protest letter. All right. What's the other defense to the Form 5472 penalty? Well, this is a defense that most people don't consider. When Congress went ahead and they enacted the tax law, which enacted this penalty for $1,000 penalty for not timely filing this Form 5472, the way that the law itself is drafted, it authorized the IRS to assess the penalty but not collect it. In other words, the IRS could assess it, but they had to refer it to the United States Attorney. The United States Attorney had to go ahead and liquidate or take the company or the person to court and sue to get that $25,000 penalty. There's a case called Farhi versus Commissioner where this is argued, which is in regarding to a penalty for the failure to timely file a Form 5471, which is not the same return, but somewhat similar to foreign international return. And in that case, that argument went to the United States Tax Court. The United States Tax Court said, look, the IRS doesn't have the authority to go ahead and collect this penalty. Only the Department of Justice does. If you look at the verbiage, the statute governing the Form 5471 penalty and the Form 5472 penalty, they're almost identical. A compelling argument can be made that the IRS does not have the authority to go ahead and collect this penalty. That should be in any protest letter that goes to the IRS. What's another defense to it? Another defense to it would come under the 8th Amendment of the United States Constitution. What does the 8th Amendment of the Constitution say? You can't have excess fines. So if the IRS is assessing a $25,000 fine for just not filing a piece of paper, arguably, that's a violation of the 8th Amendment. That should be put on any protest letter. And then finally, there's one last argument, And that last argument is the Seventh Amendment. And what the Seventh Amendment says is that anytime there's a civil penalty assessed by the government under certain circumstances, say for criminal cases or negligence, in that case, if the penalty is over $25, only a district court can go ahead and assess that penalty. IRS is not a court. The IRS is not a district court. The Seventh Amendment should always be raised. There's a recent case that was in the Supreme Court, although it was a case that was not against the IRS, it was against the SEC, which went ahead and made this pretty clear that a government agency just cannot go ahead and assess a massive penalty against somebody without offering them the opportunity to have a jury trial before a United States district court. That argument should always be raised in any protest letter. So, protest letter, what should be raised with the government? First, reasonable cause. Second, did the IRS have the ability to assess the penalty? Third, Eighth Amendment. Fourth, the Seventh Amendment. Now, let's just say the IRS protest letter is not getting you anywhere. What can you do? Well, you have a couple options to take. You have three different options to take it to court. First, you could wait for the IRS to issue a so-called notice of determination. So let's just say the IRS assesses this $25,000 penalty, and let's just say times 3. And let's just say it goes to the point in time that the IRS issues a letter that says file notice of intent to levy. If you get that file notice of intent to levy, then you have an opportunity to raise all the defenses that I just spoke about in a so-called collection due process hearing. If the IRS rejects it to the collection due process hearing, you could take it to the tax court and you could fight it in tax court. That sounds wonderful. But what did I say earlier? I spoke about the Farhi decision. So the IRS, knowing that they lost already in Farhi, do you think they're going to offer anybody the opportunity to take something to tax court? No, they're not. So your chances of being able to take this to tax court are going to be very small, if not remote, if ever, because the IRS knows better than to go ahead and give someone a notice of determination and let them go ahead and contest something like that in tax court, where they know their chances of winning are pretty small. So now we know we can't likely contest it in tax court. So what are the other two options that we have? Well, the other option could be is to, if you have the funds available, pay the penalty in full. Pay the penalty in full and then sue for a refund, sue for your interest that accrues on that penalty after you paid it, and sue for your attorney's fees. Raise all those different defenses that I mentioned earlier. Reasonable cause. IRS doesn't have the ability to assess that penalty. Eighth Amendment, Seventh Amendment. That can be raised in a case in district court after you wind up paying the penalty in full and you filed a so-called administrative claim for refund with the IRS. The problem with that is, it sounds great, but a lot of people don't have that kind of money laying around. They don't have the money to pay the penalty in full. So there might be a different way to kind of get to the courts to kind of hear this case, and that's through the so-called Administrative Procedure Act. And what the Administrative Procedure Act provides is that if a federal agency, such as the IRS, goes ahead and violates the law, or doesn't properly assess a assessment, like a penalty assessment, you may be able to go to a district court prior to paying in full and asking the court to go ahead and fashion a remedy, namely that you actually have a proper hearing before the IRS where they're considering these defenses, and hopefully that will result in the IRS removing the penalty. Now, this is an area that's evolving. There's a lot of exceptions to this rule. There is at least one case out there where there is an international penalty raised before the district court before the penalty itself is paid in full. And we'll have to wait and see how that pans out before the district court. And I'll be interested to see how that evolves for people that are assessed these large international penalties. active failure to file a Form 5472 and how they could potentially contest it in a district court prior to paying it. So, if you've been assessed a Form 5472 penalty, seek the advice of a qualified international tax attorney who has significant experience in litigation to assist you. Don't wait. Seek his advice as soon as possible. And as always, this video is made for informational purposes only. This is not an invitation for an attorney-client relationship. These penalties are serious. If you have one of these penalties that are assessed against you or a U.S. company, seek the advice of a U.S. tax attorney immediately.